Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, we have 3 dockets. We have an announcement docket, we have a trial docket, and we have a pretrial conference docket. First case is off the announcement docket. Is cause number 24CCCR 0246. Linda Wyckoff. Ms. Wyckoff, would you please come forward? Good morning, Ms. Wyckoff. Your full name is Linda Wyckoff?
Linda K. Wyckoff.
Linda K. Wyckoff. How are you doing, Ms. Wyckoff? That's good. Cannot be better than being blessed. Now, Ms. Wyckoff, you're represented in your case by your attorney, Attorney Peter Dahl. Attorney Dahl, how are you doing?
Pretty fair, Joe.
And the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine, thanks for asking. Now, Mr. Dahl, what is your announcement in Ms. Wyckoff's case?
We would like a trial setting.
Reset it for trial, okay. Okay, this case will be reset for trial for December 16th of 2024. Ms. Wyckoff, your attorney is gonna get you reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Dahl, do you have any more cases?
I have a Danny Ariola.
Uh,
I have that on my calendar and
yeah, here we go. It's on a pretrial conference.
he's back in the back.
Hmm?
He's back in the
Yes,
back.
ma'am. Just, yeah, just step over here. She'll give you your reset. Next case is
Ariola.
cause number M332660. Case is styled the state of Texas versus Danny Chavez Ariola. Mr. Ariola, your full name is Danny Chavez Ariola.
Yes, sir.
How are you doing, Mr. Ariola?
Good, how are you?
I'm doing fine, thanks for asking. The state is represented in this case by Attorney Kyle Gasper. Attorney Gasper, how are you doing?
I'm good, Judge. Thank you for asking.
You're welcome. Now, Mr. Dahl, what is your announcement in Mr. Ariola's case?
Well, Judge, if you look back in the history of the case, I wasn't the original lawyer. And Mr. Ariola was told by the original lawyer that he'd been granted pretrial diversion. And I went to confirm that within the last 10 days with the staff, and they don't even show that there was an application made. I would like the time to do that.
You like to apply for pretrial diversion?
Yes, sir. And the next sign-up date's in December, so there's time. I just haven't had a chance to get him in to write his letters. So. And I can't explain the reason.
Okay, give us a reset date, second week of December.
December the 9th.
Yeah, December 9th of 2024. That'll be a week after the sign-up date for
Okay.
pretrial diversion.
All right.
Okay. You can get your reset, Mr. Ariola, from your attorney. Once you get your reset, you're free to go. And Mr. Dahl, once you get your reset, you'll be free to go as well.
Thank you.
You're welcome. Thank the Lord. Chelsea Petaway? Do we have a, how are you doing?
Doing okay.
Now your full name is Chelsea Nicole Petaway.
Sir?
I was looking at my notes on the docket sheet. It says something, Rife Kimler to send letter of rep. And that was August the 19th, the 20th to have cert, okay, to give enough time to recover, okay. Did Mr. Kimler send a letter of rep on this case?
Yeah, the last couple of times I've been here, that was an issue, so I'm not sure.
You hired him, right?
Yeah, he's hired, yes.
Okay, I'm gonna call his office. Well, we're gonna, I guess we can just have a seat. She's gonna call his office and find out what's going on. Okay. Is there an old case? Oh, okay, we have two cases. Deep. Must be Alan Walker.
Basically, what's gonna happen today is gonna happen as far as Sunday. But it's just like, it's a month. Nothing's changed. Once I know.
That isn't true. Aaron Hadley? That person, he's on Bridge Rock office. I didn't show him as being here. Marvin Booker. Jalen Gasper. I was just calling the people who. Everybody. Oh, yeah. Hey, Jeff, can I have a constant paper? Okay. Is this Chelsea Pettaway? The court coordinator just called Mr. Kimmel's office.
Right.
And the secretary informed her that you were a former client.
No, It's been being put, I have had him hired for other cases, but he is hired for this case specifically. And he's been in court saying that he was representing me in this specific case. But they, between the two of them, the secretary, or his secretary and him, they were supposed to give y'all a letter. And I've been in this court before you
Yeah,
2 to 3 times that he was supposed to send the letter to the court.
yeah,
For-
but
and that
what we,
happened. But
I guess,
I have the documentation that I hired him.
you do?
Yeah, not on me, but I have it. So-
Okay, well,
But I did talk to him.
And he knows,
And she said she didn't have any paperwork.
yeah,
okay,
that's not, that's some kind of mishap on the,
okay,
Let me.
okay. So she's gonna text him. He's supposed to be in this court, on some other cases as well.
okay,
So he should make an appearance in here. Okay, just have a seat.
all right.
Okay, now where was? Burbank. Yes, Your Honor. I don't see you on the docket. Yeah, I don't. Yeah, but I don't see your name on the docket.
My boss,
Let me see, give me what you have. And
Mr. Jasper.
Jasper, there's a Jasper.
Well,
Jasper?
Yeah, there is a Jasper on the docket. I
Sir,
see.
attorney.
well,
Jasper. Okay, let's see, this is cause number M333-240, case of solid state of Texas versus Aquila Michelle Renfro.
Yes.
How are you doing, Ms. Renfro?
Fine.
I'm doing fine, thanks for asking, Ms. Renfro. You're represented in your case by your attorney, Langston Adams. Attorney Adams, how are you doing?
Doing well.
And Mr. Adams, I see he was just appointed in August. What is your announcement in Ms. Renfro's case?
Just one reset. I gave her PC information and plea offer. So, We'll talk about it in the office and then
So we'll reset it on the announcement docket.
yes, just the announcement document.
Okay, give us a reset date.
So this is another announcement,
Yes.
December 9th.
That's fine.
Okay, this case will be reset December 9th, 2024. Ms. Renfro, your attorney's gonna get your reset. Once you get your reset from your attorney, you're free to go. And you have a blessed day. And Mr. Thank you.
Thank you.
Mr. Ibarra, you can get, Donald Ray Taylor. He's in holding cell. That is motion for continuances.
Should be space first, you know, maybe.
Yeah.
Keep on trial, I think.
Yeah. Let's see, motion for continuance, that's the first one. I see.
It's coming?
Oh, he's not there?
He does have felony.
Did he have a felony case today?
I'm not certain if they're set today, but he does. Cases. I can check, Your Honor.
Was it set today?
Huh?
No, they appear to be set for January, Your Honor.
Oh, well, so they didn't bring him over.
No.
No, that's.
Is this, that's what they said, the felony is set. So, the state filed a continuance and, Mr. Adams,
I'm not gonna post the.
Yeah.
okay, this is
That's
their,
their
this is their first continuance. Apparently, you was just,
I was on a jail run, I think.
yeah, you was just appointed in August. Okay, okay, I'll sign this motion for continuance. Do you have any other cases?
That's it?
Okay, Mr. Make sure. Yes, we did Renfro and we did Taylor.
I think that's
Yeah.
it.
Yeah,
It's not.
yeah, that's it. You're free to go. Huh? Yeah, we're gonna keep it on the trial docket.
No problem. Thank you, Officer. Appreciate
Okay.
it. Thank you, thank you.
Okay. Here you go. There you go. Let's see that. Samuel Hayden Falk. Mr. Falk, your full name is Samuel Hayden Falk?
Right.
How you doing, Mr. Falk?
Right.
That's good. I'm doing fine. And Mr. Falk, you represented by your attorney, Attorney John Macy. Attorney Macy, how are you doing?
Your Honor, thanks for asking.
And Mr. Macy, what is your announcement?
Your Honor, still a trial. This
Ready.
is the continuation from the mistrial that we had about a month ago, if you
Okay.
recall.
So your announcement ready?
Yes.
State,
Stays ready, Your Honor.
okay. See y'all at 1:30. You have any other cases today?
Not anymore.
Oh, that's right, we took care of that one earlier.
Yeah.
Falk, he's on page 5. Okay, we'll see y'all at 1:30.
That's
The
it.
time
Thank
we
you.
pick the jury. Okay, next. Mr. Macon. Okay. Alva Shillings. Mr. Shillings, your full name is Alva Leon Shillings Jr.
Yes, sir.
How are you doing, Mr. Shillings?
Bless. How are you today?
I'm blessed as well. Now, Mr. Shillings, you're represented by your attorney, Attorney James Macon, Attorney Macon. How are you doing?
It's Monday morning, Judge.
Okay, and now, Mr. Macon, what is your announcement in Mr. Shillings' case?
Your Honor, I'm gonna ask for 2 more weeks. I've got a offer that I need to go over with Mr. Shillings.
Give,
I believe it'll be a plea, but
okay, give us a 2-week reset.
It'll be November 18th.
Okay, this case will be reset to November 18th, 2024. Your attorney is gonna get you reset. Once you get your reset from your attorney, you're free to go and you have a blessed day. Mr. Macon, is this your last case?
that's it. Your
Okay,
Honor.
you're free to go and you have a blessed day.
Thanks, sir.
You're welcome. Is Dana Spencer here? Or Dante Spencer?
Judge Dante Spencer is down at drug court right now. I haven't been there yet.
Okay,
I came here first.
okay, so, cool, okay, so it's gonna come back, okay,
I'll send him back when I go down.
okay, let's see if we have okay. Sagar Patel,
Yes.
Morning, sir.
good morning, Mr. Patel. Mr. Patel, how are you doing?
Good, how about yourself?
I'm doing fine, thanks, thanks for asking, Mr. Patel. You're represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
I'm great, Judge. Thank you.
And Mr. Gertz, what's your announcement in Mr. Patel's case?
So, Judge, this is going to be my announcement for all of my trial cases. We filed a motion for continuance, I think, on Friday, in all of these cases, I believe. We have a sentencing hearing going on this week in Judge Troncalli's court in the TPC criminal litigation, the TPC explosion litigation.
Oh,
And so we have it sounds weird, but we're gonna have like a civil trial in the middle of our criminal sentencing that's going on in Judge Troncalli's court this week to determine restitution. So it's gonna take probably the rest of my life, but nonetheless, that starts tomorrow. And so I'm not ready for trial in any of these cases because I'm gonna be there doing it.
okay. Now, this is a pretty old case.
I understand.
Yeah. We need to get this case to #1 setting. That's this, he had a felony case at some point, yeah.
Yes,
but-
Judge.
But it doesn't come out of, I doubt if it's out of the same criminal episode.
I think there is one separate case that is outside of the felony. That's correct, Judge.
Yeah, Yeah. Give us a number one setting on this case.
It could be different than 16.
Okay. Okay, this case is gonna be, first of all, I'm gonna grant the motion,
Thank you, Judge.
and then, the case will be reset. Now, well, state, Max, do you have any objections to the motion?
No objections, Your Honor.
And Judge, that week of the 16th, I'm
Uh,
fine with resetting it to another day, but the week of the 16th is my stepdaughter's graduation from college.
Okay, could you put it up a week?
The 9th is fine now.
Okay. Okay, so that's Patel, December 9th. Trial number one. And, we got a motion. Continues. Ready? Okay. Here you go. Did I say, I think I said. Yes. Okay, Mr. Patel, you can get your reset from our coordinator. Once you get your reset, you're free to go on your best day. Okay. All right, same to you. Daniel Paul Wallace. You have a motion for continuation in that case?
I don't think that was a trial setting, Judge.
Oh, okay. It is.
This trial.
It's
setting?
on the
Oh, that's-
yeah,
Yeah.
jury trial.
There's one that is and one that isn't.
Oh, okay. Well, that's the confusion.
Hold on a minute, they must be. I'm looking at it on the jury trial docket.
Either way, my response is going to be the same thing. I'm moving for continuance for the same reasons, regardless of,
Okay.
I think we may have filed it in one and not the other. I
Yes,
don't know. what we
state,
did.
you have any
There's some
objections?
confusion about these cases, Judge. So.
Okay,
This is one that was technical.
We filed one and one and not the other. His JP cases got dismissed. It's not worth anything.
okay, Mr. Wallace, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go on your best day. Let's see. I don't know, this is one on the announcement. Dylan Feldman. That's not it.
This isn't mine.
Yeah. Dylan Feldman. This is a new case, well. 2023. Yes, yeah, this is yours.
Yeah.
Oh, excuse me, Ryan Feldman. I mean, Dylan Feldman, that's right. Dylan Feldman. He,
It was what?
he did not, he didn't answer. Want to try to,
I've got him in my notes, Judge, but I haven't talked to him, and I didn't have it on my calendar for whatever that's worth. Oh, I do have it on.
There is.
Yeah, okay. It was just on for an announcement, so.
right, well, is he here? We can give you some time to try to, does he have a felony? On the same day. Yeah.
I'll check on the judge.
Okay, we'll give you a chance to check on it. Okay. Let's see, Bert's, you have another one.
Michael Hall, Judge, the trial setting.
You have one on the pretrial conference. Tommy Clark,
Yes.
Mr. Clark. Your full name is Tommy Jean Clark?
That's correct.
How are you doing, Mr. Clark? That's good. Mr. Clark, you're representing the case by your attorney, Attorney Ryan Gertz. Attorney Gertz, what is your announcement in Mr. Clark's case?
Judge, I think we just get another pretrial setting. In this case, if we can. I think there was some discussion with Mr. Hubel in our prior setting. One of the complainants is deceased, which is not an automatic, obviously, disposition, but I think in this case it would, given that it is only based, the allegations are only based on a non-contemporaneous police report. I think they may be here, so.
Okay. You gonna put it on, keep it on pretrial, you said?
Yes, Judge.
Give us a reset on Tommy Clark, page 1 of the pretrial conference document.
December 2nd.
Okay. That's sitting in that thing. Great. Great. So we would, for Spencer, who's in felony court,
Yes, sir.
and then we want to,
Michael Hall was present. Michael Hall was on the trial docket, and we filed for a continuance of his case.
you did? Okay. Michael Hall, how you doing, Mr. Hall?
How about yourself?
I'm doing fine. Thanks for asking. Mr. Hall, you represented by your attorney, Attorney Gertz. And Mr. Gertz, I have before me a motion for continuance. State, you have any objections?
No objections, Your Honor.
Well, Mr. Hall, want to sign this motion for continuance? You want to keep it on the trial docket, Mr. Gertz?
Yes, Judge.
Give us a trial date on Michael Hall.
They're all the same.
Yes. Probably do it on another day.
Okay. Hold on one second.
Okay. This case will be reset December 2nd, 2024. For trial, Mr. Hall. Attorneys, you can get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day.
I'm gonna go deal with Mr. Spears.
Okay.
In drug court, and then I'm gonna send him over here. We're also gonna track down Feldman and figure out where he is and get him here.
Okay. Okay.
May I be excused?
Yes, you may be
Thank you,
excused.
Judge. Hey, Mike, anything else?
Yes, hold on a minute. You didn't have to, Clark was on there like that. Yeah, he didn't have to follow motion continuous and Clark. I didn't, yeah. Mr. Gertz, I was just telling her, you didn't have to follow motion for continuous in the Clark case. There was a motion for continuous. His case wasn't on the trial docket.
Okay,
Okay,
I think they just did it out of
Caution.
abundance of caution.
okay, that's fine.
So, thank you.
All right. This is cause number 23 CCCR 1216. Case is styled in the state of Texas versus Darius Alexander Perkins. Mr. Perkins, is that your full name? Mr. Perkins, would you please raise your right hand? Mr. Perkins, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Perkins, you may put your hand down. How are you doing, Mr. Perkins? I'm doing fine, thanks for asking. Mr. Perkins, you're represented in your case by your attorney, Attorney Marvel Provo. Attorney Provo, how are you doing? I'm doing fine, thanks for asking. Ms. Provo, do you waive a record in Mr. Perkins' case? Mr. Perkins, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, Mr. Perkins, it alleges that you, Darius Alexander Perkins, on or about May 5th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of interference with public duties. Mr. Perkins, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Perkins, how do you plead? Guilty, not guilty, and no contest? Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Perkins, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? This document is also labeled as State's Exhibit Number 1. On page 2 of this same document, there's a set of initials DAP on the line next to the box is checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal. Well, let me go back. On the same document, on page 3, there's a signature above the line that's titled Defendant, is this your signature? And on the next document that's titled Trial Court Certification of Defendants of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box says check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box says check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? And Mr. Perkins, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Perkins, are you a citizen of the United States?
So for six one.
Any objections?
No.
No objections. State's Exhibit Number 1 will be admitted. Ms. Provo, you've advised and counseled Mr. Perkins. Is there any evidence that he is currently mentally incompetent to stand trial? And Mr. Perkins, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes.
Mr. Perkins, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The agreement is 180 days, probably over 1 year, with a $300 fine and 40 hours community service.
What is this court cost? Mr. Perkins, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County for the court-appointed attorney fees of $250. Now, your total monthly installments, that is, the total amount that you will be required to pay each month while you are on probation, is $158 a month. Will you be able to pay the $158 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Mr. Perkins, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Okay, Mr. Perkins, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Perkins, please stand in front of the coordinator, follow her directions. Once you're finished following her directions, you'll be free to go and you have a blessed day. Cody Lee Garrett. Mr. Garrett, this is cause number M332454. Case is filed the state of Texas versus Cody Lee Garrett. Mr. Garrett, is that your full name? Mr. Garrett, would you please raise your right hand? Mr. Garrett, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Garrett, you may put your hand down. How are you doing, Mr. Garrett? That's good, Mr. Garrett. You're represented in your case by your attorney Marvel Provo. Attorney Provo, do you waive a record in Mr. Garrett's case? Mr. Garrett, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Garrett, it alleges that you, Cody Lee Garrett, on or about April 7th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Mr. Garrett, do you understand what you have been charged with? And to this charge, Mr. Garrett, how do you plead? Guilty, not guilty, no contest?
That's it.
No contest. Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Garrett, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, a set of initials CG on the line next to the box is checked, no continuing, which means no contest. Place your initials on this document. On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
That's it.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement? Second box is checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document that is titled Discovery Certification. Do you recognize this document?
So,
And is this your signature on the line that's titled Defendant? Mr. Garrett, before you sign and initial all of these documents that I just showed you, did your attorney, Ms. Provo, go over these documents with you? And did you understand everything that she went over?
Okay.
And is everything in these documents true and correct to the best of your knowledge?
correct.
Mr. Garrett, are you a citizen of the United States?
Zero for 6-1.
Yeah. No objection. State's Exhibit Number 1 will be admitted. Ms. Provo, you have advised and counseled Mr. Garrett Is there any evidence that he is currently mentally incompetent to stand trial? And Mr. Garrett, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation? Mr. Garrett, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find it the evidence is sufficient to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
That agreement is to 30 days time served, court calls tax and charge in this case.
Okay, Mr. Garrett, the state is offering that you serve 30 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you've already served 30 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Garrett, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Garrett, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Garrett, you're gonna stand in front of our court coordinator, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. Next case is Rachel G. Woodson. Okay, Ms. Woodson, your full name is Rachel G. Woodson.
Yes, Judge.
Okay, how are you doing, Ms. Woodson?
I'm blessed. How are you?
I'm doing fine. I'm blessed as well. Now, Ms. Woodson, you're represented by your attorney, Attorney Marvel Provo, Attorney Provo. What's your announcement in Ms. Woodson's case?
We're not ready at this time, Your Honor. This
Oh.
is the fact that Ms. Woodson has a witness who just survived from this time in the hospital. That is necessary for her case.
Okay. Did, now State, you have any objections to the continuance?
No, Your Honor.
Okay, now, is this their first?
It is not, Your Honor.
It's our second.
Huh?
The first was due to her son.
Oh, yeah, that was, some type of accident or something. Yeah. So you're not opposed?
I am not opposed.
Okay. The defendant's motion is continuous, no objection. Okay, give us a trial date.
December 16th.
Okay. Okay, this case is reset to December 16th for trial.
Your Honor, so we got a study early in
Okay. No, they want to set it earlier now. We have a number one case set on the ninth, right? Because that was Mr. Gert's case.
We have,
Okay, but I don't think we have a number one on the second. Because Gertz, we reset one of his on the second too, but it wasn't number one.
okay.
Okay. So, case will be reset to December 2nd, 2024. Ms. Woodson, your attorney is going to get your reset. Once you get your reset from your attorney, you're free to go, and you have a blessed day. All right.
Maybe
Yeah, you may be excused. You have a blessed day. Yes.
I have two announcements.
Okay. hold on. Jonathan Abshire, Jonathan Ray Abshire. Okay, Mr. Abshire, your full name is Jonathan Ray Abshire.
Yes, sir.
How you doing, Mr. Abshire?
Sir, you.
Hmm?
Good. You.
I'm doing fine, thanks for asking. Mr. Abshire, you represented in your, well, actually, Mr. Abshire, you have three cases. Two of the cases you're represented by attorney Alan Parker. And you have a third case, which is a new DWI open container. And I don't show
It,
an attorney.
it just, I think the fifth day of September, it was just a new
September
date.
26th, yeah.
Yeah, so he's talked to me about that, Judge, and I'm gonna represent him on that. I didn't know they had actually filed it yet till this morning, so
Yeah,
we're obviously gonna need a little more time so we can do discovery on that. The state already has it, obviously,
okay.
which we didn't know, but
There was some bond conditions. This is his second DWI charge. This is Abshire, Jonathan Abshire on page 6.
he's
Of
got
the,
the same bond conditions he does on the other one, and he's not driving, Judge. So.
Yeah, I know, I don't think he was required to have a interlock on the other bond conditions. Because if he would have,
He's not driving at all. He didn't have.
okay.
Yeah.
But these bond conditions, I have to give him that's gonna be in place unless he may get a car or something. Let me see. Okay. It's taking a while for you. It's a little slow this morning. I don't see any bond conditions. Street D in that one. Look at the next one. Let's see the next one. No, I don't, motion, no, he doesn't have bond conditions. Okay, let's see. There's 2, 3, C. Okay, I'm gonna go over these, then I'm gonna give them to him. We'll have to make a copy for him. Let's see. Okay, Mr. Abshire. I have a document that is titled Standard Bond Conditions in County Court at Law Number 2, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. You understand that condition? Condition number 3 does not apply. Condition number 4 does apply. And this states that a defendant whose information charges any offense listed under section 49.04 through 4906, that's what a DWI statute is, of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of any vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. You understand that?
Yes, sir.
Condition, all right. And condition number 5, the defendant shall obtain, maintain, pay for, and have no violations of ignition interlock mobile breath device. Any violation will be grounds for revocation. And do you understand that condition? And condition number 6, the defendant must attend AANA meetings 3 times a week and provide proof to the court. So every time that do you understand that condition?
Yes.
So when you come to court, you're gonna have a sheet, it's a sign-in sheet, and you got a copy of this here. I'm gonna give you this sign-in sheet. That's a sign-in sheet that you can take with you to AANA. And if you need to find some locations, that's a list of the locations. So your case is gonna be reset. Did you give us a reset date? Yes, he has this new case. Okay, this case was reset to December 9th, 2024, and Mr. Parker, you're gonna get us a letter rep on that on the third case?
Sure.
Okay. All right, now, Mr. Abshire, your case is gonna be reset to December 9th, 2024. You're gonna get your reset and your bond conditions from your attorney. You'll be free to go and you have a blessed day. All right.
One more, Judge.
Yeah,
Ryan.
Ryan
Jackson.
Stephen Jackson. Mr. Jackson, your full name is Ryan Stephen Jackson? Okay. Mr. Jackson, how are you doing?
Doing good. What about you?
I'm doing fine. Thanks for asking. Mr. Jackson, you're represented by your attorney Alan Parker. Attorney Parker, what's your announcement in Mr. Jackson's cases?
You know, we need one more reset. We had, there's an issue early on that this was gonna be a dismissal, then they talked to the victim and the victim is cooperative, so I think we had a plea bargain agreement, but it involved no contact. They're living together and been living together for a year and a half, and the prosecutor didn't realize that, so she's trying to get hold of the victim And, she apparently she hadn't been able to get a hold of the victim, so I'd like to, a couple of weeks, I can talk to her to figure out how we're gonna handle this now, if that's still gonna be a requirement or not. As of now, that's the same offer as last time, but she was gonna try to resolve that, but she wasn't sure.
Your Honor, this is Haley Simmons's case.
Oh,
Her notes on the file indicate that she is in the process of getting in contact with the victim. We have not been able to fully contact the victim to confirm
Was that
everything
the-
that we've heard.
oh, the last time that we had the court setting, was they supposed to contact them?
The last time that we thought that she wasn't going to, well, initially it was, she was gonna try to contact her, that, she was, whether they're gonna pursue the case or not. And then when we got to court, she didn't realize that they were living together. And I told her that, she goes, oh, well, I need to contact the victim. And she hasn't been able to contact the victim yet since the last court date.
Okay, now,
So,
well, we got. The main issue is, I assume we have some bond conditions in this case.
I don't know when there's a
Let me
contact.
see. Yeah, because if there's.
I think he's gonna be in the process of moving out, so it's gonna resolve itself anyway, Judge, if we could.
Okay, because
I
yeah,
think
you
sure-
can't
I
have
think-
any contact if, yeah, so those bond conditions are in place.
Okay.
So let me ask this question. So the district attorney office is gonna try to contact the victim
Correct, Judge.
and to talk to the victim about maybe the resolution
The
of
whole
this case?
thing, yes, Judge.
Okay. So how much,
I'd say give us 3
Time.
weeks,
okay,
or, I mean, either 3 weeks or a regular reset, I mean, because if
Yes,
if
just a
it's gonna go
standard
forward,
reset?
yeah, that'd be fine, because if he's gonna go forward, he's gonna move out, and.
okay, give us a standard reset.
Who is it on?
Ryan Steven Jackson,
It's December 9th.
okay. Okay, so we're gonna reset this to December 9th, 2024. The other thing is, the guy's moving out, I mean, he can't have any contact. I guess you're gonna have to figure out how he's gonna get his stuff
We're working on
where
that.
they won't be able to be in contact with each other.
It's not gonna be an issue.
Okay,
All right.
all right. Yeah, you have any other cases?
No, Judge, thank you.
Okay, you're free to go. Once you get your reset and you have a blessed day, you're free to go as well, Mr. Jackson. That's on that other guy, on, Mr. Abshire.
Yeah, yeah.
I'll have to make some copies.
Thought she just did.
She did. That should be a copy. Is
I
that,
think she gave it to him. I think
Oh, she did give it to him? Okay.
gave,
She gave it to.
oh, she gave Mr. Abshire, you have your bond conditions? Oh, okay.
Al. Okay.
Okay, the person that's on Zoom that has iPhone, please state your name.
Yes, sir. Dylan Feldman, Dylan
Oh, this is
Feldman.
Mr. Gert's case. Okay.
Yes.
Mr. Feldman, your attorney was here earlier. Just, he went down to felony court on another case and he's gonna come back.
Okay.
Just put your mic on mute, and then when we call your case, you can take it off of mute. Okay.
Okay. Thank you.
Okay, you welcome. Bointello? Ruth? Bointello? Oh, this is the dismissal.
Yes, Your Honor.
Okay, this is cause number 24 CCCR 0984. I have before me a document that is, well, first of all, the case is styled the state of Texas versus Ruth Aned Bointello. Bointello. How are you doing, Ms. Bointello? I'm doing fine, thanks for asking. You're representing your case by your attorney, Charlie Rojas. Attorney Rojas, how are you doing?
Doing well, Judge.
And Mr. Rojas, you waive the record in this case?
Yes.
Mr. Rojas, Ms. Bointello, I have before me a document that is titled Motion to Forfeit. Ms. Montello, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Now, before you sign this document, did your attorney go over this document with you?
Yes.
Did you understand everything that your attorney went over? And is everything in this document true and correct to the best of your knowledge?
Yes.
And Ms. Montello, you're requesting that the court forfeit the weapon in this case to the Needham Police Department, is that correct?
Yes.
Okay. Ms. Montello, I'm signing the forfeiture in this case. State, I have before me a motion to dismiss for forfeiture of the weapon.
Yes, Your Honor.
Okay, signing this motion to dismiss. Okay, Ms. Montello, I just signed the motion to dismiss this case. Your attorney is going to get a copy of this motion to dismiss. Once you get a copy of the motion to dismiss, you're free to go. And you have a blessed day.
Thank you.
And Mr., let's see, Rojas, you have any other cases?
I do, Judge. I have Ms. Guidry on Zoom,
Okay,
and then I have a plea after that.
okay. Let's go.
Ms. Guidry is on the trial docket, Your Honor.
Motion 15. We don't have- this is cause number 23 CCCR 1378, case of style of the state of Texas versus Kiara Gidrich.
Yes, sir. How you doing?
Is that your full name?
Yes, sir.
How you doing, Ms. Gidrich?
Fine. And you?
I'm doing fine. Thanks for asking, Ms. Gidrich. You're represented in your case by your attorney Charles Rojas. And Attorney Rojas, what is your announcement in Ms. Gidrich's case?
Defense is ready, Judge.
State?
The state has a motion for continuance on file in two of Ms. Guidry's cases.
We do. Could you give me a copy of the motion?
And the third one is a dismissal, Your Honor.
Which student?
State has a motion for continuance in 23 CCCR 1378 and M 332530.
332. 332, 531. 68.
Yes, Your Honor.
Now, Mr. Ross, you have any objections to the state motion continues? Do you? Let me see. Let me get a copy of it.
I've seen the motion, Judge. I don't have any objection to it.
Okay. States, okay. Okay, so we'll sign those motions and have a good keep our motion to dismiss. Mistake. I just signed the motion to dismiss.
Thank you, Your Honor.
Okay. You gotta be that day. This on the trial docket. State motion. Now, Miss Gidry,
Yes, sir.
your hindering apprehension case or prosecution is gonna be dismissed. And the two theft cases, we're gonna reset those for trial. Is that correct?
Yes.
All right, so Ms. Gidry, stay in contact with your attorney, your bondsman. They will be given notice of your reset date. Give us a trial date on Gidry. Okay, your trial will be set on these cases for December 16th of 2024. You're free to go. Stay in contact with your attorney, your bondsman, and you have a blessed day.
Okay, thank you.
And Jose Antonio Gonzalez Mina.
That Mr. Manna does not speak English, so I'll be translating for us.
Okay. This is cause number 23CCCR 1234. Case is style of state of Texas versus Jose Antonio Gonzalez Mina. Mr. Mina is present with his attorney. Mr. Mina speaks Spanish, and his attorney is fluent in Spanish. Mr. Rojas, would you please raise your right hand? Mr. Rojas. Mr. Rojas, do you swear to interpret Spanish to English and English to Spanish, so help you God?
I do.
Okay, you may put your hand down. Ms. Rojas, ask Mr. Mina if his full name is Jose Antonio Gonzalez Mina.
Yes.
Okay. And you can ask Mr. Mina to raise his right hand. Mr. Mina, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Mr. Mina, you may put your hand down. Ask Mr. Mina how he's doing.
Good.
Good? That's good. I'm doing fine. Now, Mr. Mina, you're represented in your case by your attorney Charles Rojas. Attorney Rojas, do you waive a record in Mr. Mina's case?
We do, Your Honor.
Okay, Mr. Gonzalez Mina, I have before me a document on my computer that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Jose Antonio Gonzalez Mina, on or about April 30th of 2023, while you were operating a motor vehicle in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Mina, do you understand what you have been charged with? And to this charge, Mr. Mina, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
You know, you're pleading guilty because you are guilty.
Yes.
Mr. Mina, I also have before me a document that is titled Misdemeanor Admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes.
On page 3 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the first page of this document, there's a set of initials at the bottom of this document below the paragraph that's titled citizenship. Did you place your initials on this document?
Yes.
And this paragraph states that if you're not a U.S. citizen, a plea of guilty or nolo contendere may result in your deportation, exclusion from admission to this country, or denial of naturalization under federal law. Do you understand that statement?
Yes.
And do you still want to go forward with your plea?
Yes.
Okay. On page 3 of this document, I mean, not page 3, but on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Okay. I also have another document that is titled For All Foreign Nationals Except Those from Mandatory Notification Countries. Now, Mr. Gonzalez Mena, what country are you from?
Cuba.
You're from Cuba?
Yes.
Thank you. And he is not a U.S. citizen, is that correct? Okay.
He's a resident.
All right. Now, on this document that is titled For All Foreign Nationals Except Those from Mandatory Notification Countries, the last sentence states, do you want us to notify your consular officers at this time? And there's a circle around the word no. Is this your signature on this document?
Yes.
And did you circle no?
Yes.
Okay. Now, Mr. Gonzalez Mena, before you signed and initial all of the documents that I just showed you, did your attorney go over these documents with you in Spanish?
Yes.
And did you understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Sarah for 6-1.
No objection.
No objection, states exhibit number 1 will be admitted. Mr. Rojas, you have advised and counseled Mr. Mena. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Rojas, pursuant to the case of Padilla versus Kentucky, did you advise Mr. Gonzalez Mena about the consequences of pleading guilty no contest to this charge?
I did, Your Honor.
Okay. Mr. Gonzalez Mena, your attorney, Mr. Rojas, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Okay, Mr. Gonzalez Mena, I will accept your plea of no contest.
He pled guilty, Your Honor.
I mean, excuse me, your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
For defendant's plea of guilty, the state has offered 180 days probated over 15 months with a $750 fine, 60 hours community service, the installation and maintaining of an interlock device, and DWI standard conditions of probation.
Mr. Ross, were you appointed in this case?
I was not.
What's the court cause? Gonzalez Mena. Okay. Mr. Gonzalez Mena. The state is offering that you serve 180 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 6 months. During the 6-month probationary period.
Excuse me, Judge, 15 minutes.
What I said?
6.
Oh, let me back up. Mr. Mena, you are, the state is offering that you serve 180 days in the Jefferson County Jail. However, you'll not be required to serve any time in the Jefferson County Jail because you'll be on probation for a period of 15 months.
Yes.
Okay. You'll also be required to pay a fine of $750. You'll be required to pay a probation fee of $60 a month. You'll be required to pay a urinalysis fee of $15 a month. You'll be required to pay a $15 reimbursement fee. You'll be required to pay court costs of $377. And you'll be required to pay a DWI conviction fine of $100. Your total monthly installments, that is the total amount that you will be required to pay each month, is $169 a month. Would you be able to pay the $169 each month?
Yes.
You'll also be required to pay the Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. You'll also be required to perform 60 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of DWI probation. Mr. Gonzalez Mina, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes, that's good.
And do you accept the state's offer?
Yes.
Mr. Gonzalez Mina, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Mina, you're going to stand in front of the court coordinator. Follow the directions. Oh, just have a seat and wait for your name to be called.
I think that's all I have.
Okay, Mr. Rojas, you're free to go and you have a blessed day.
Thank you.
You're welcome. Trenton Watts. Okay, this is cause number 24 CCCR 1438. Case of style of state of Texas versus Trenton Watts. Mr. Watts, is that your full name?
Yes, sir.
Mr. Watts, would you please raise your right hand? Mr. Watts, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Watts, you may put your hand down. How are you doing, Mr. Watts?
Pretty good, how are you?
I'm doing fine. Thanks for asking, Mr. Watts. You're represented in your case by your attorney, Attorney Benjamin Jeffries. Attorney Jeffries, how are you doing?
Well, Your Honor, thank you.
And Mr. Jeffries, do you waive a record in Mr. Watts' case?
Yes, sir.
Mr. Watts, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Trenton Watts, on or about May 14 of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of terroristic threat, family violence. Mr. Watts, do you understand what you have been charged with?
Yes.
And to this charge, Mr. Watts, how do you plead? Guilty, not guilty, or no contest? Now, you're pleading no contest freely and voluntarily? And are you pleading no contest because you didn't wish to fight or contest the charges? Mr. Watts, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit 1. You recognize this document?
Yes.
And on page 2 of this same document, there's a set of initials TW online. Next to the box is check Nola Contendra. So you place your initials on this document.
Yes, sir.
And on the next document, that's titled, on the same document, but on the third page, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification. think he must have put T Watts on one and Trenton Watts on the other one. Okay, you could just write out your full name on the line that says defendant. You could use that as an eraser, just turn it over and back and just erase it. Yeah, just erase it.
Right?
Okay, Mr. Watts. Is this your signature on the line that's titled defendant? And on the next document, it's titled trial court certification, the defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement? You understand that statement?
Yes, sir.
Okay, I also have a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Watts, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, he did.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Watts, I also have now, Mr. Watts, are you a citizen of the United States?
Yes, sir.
State offers states one.
Any objections?
No objection.
No objection, states exhibit number one will be admitted. Mr. Jeffries, you've advised and counseled Mr. Watts. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Watts, your attorney, Mr. Jeffries has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Watts, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 1 year deferred probation, $500 fine, 60 hours of community service, anger management, no contact with John Watts, and court costs.
Mr. Jeffries, were you appointed in this case?
Correct, Your Honor.
Okay. What is this court cost?
277.
277. Okay, now, Mr. Watts, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, reimbursement fee of $15. You will also be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly installments, that is, the total amount that you will be required to pay each month while you're on probation is $177 a month. Will you be able to pay the $177 each month?
No.
Okay. Let's see his affidavit of indigence. This is Trenton Watts. Mr. Watts, I'm gonna show you a document that has been. I'll show this, I'm gonna get this document to your attorneys. He'll hand it to you to review. Okay, now, Mr. Watts, is everything on that document still true and correct today?
Yes, yes, sir.
Okay, Mr. Watts, the court is gonna find that you're indigent. Let's see on this here.
Move this back on.
Now, Mr. Watts, the court is gonna find that you're indigent based on the finding of indigency. The fine of $500 plus the court costs of $277, which is a total of $777, will be converted to community service. It will be converted to 62 hours of community service. And the attorney's fees of $250 will be waived, which means you won't have to pay it, pursuant to Article 26.05G-11 of Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived also pursuant to Article 102.018 of the Texas Code of Criminal Procedure. Now, the probation fee will remain the same, $6 a month, and the urinalysis fee of $15 a month. So that will come to a total of that you'll be required to pay each month. $82 a month. Will you be able to pay the $82 a month? Okay. Now, Mr. Watts, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Watts, I'll follow the plea bargain agreement that you have entered into with the state, along with the court's finding. This will conclude your case. Now, Mr. Watts, if you successfully complete your probationary period, your case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to Mr. Jeffries about the non-disclosure because he's quite competent in those matters. Now, Mr. Watts, before you leave and finalize this paperwork, I need to go over a document that is titled Model Written Ammunition on Ineligibility to Possess a Firearm Ammunition. And you have that document before you, and it reads as follows. In accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number one, you are an entry of order of judgment ineligible under Texas law to possess a firearm ammunition. Number two, beginning now, if you possess a firearm ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, a firearm meaning any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion of burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part, a folding knife blade, or other characteristics of weapon made illegal by Penal Code Chapter 46, and that is one, an antique or carrier firearm manufactured before 1899, or two, a replica of an antique or carrier firearm manufactured before 1899, but only if the replica does not use rimfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure Article 42.013, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Watts, the written admonition that you have before you is for your records. This will conclude your case. Please have a seat in that first chair on the wall and wait for your name to be called. Once your name is called, you'll follow the directions of the bailiff, and you have a blessed day. Yes. Oh, yeah, let me have him come back. Yeah, have him come back. I forgot to mention something else. Now, Mr. Watts, you also be required to perform 60 hours of community service.
Yes.
Your regular hours in addition to the 62, so that'll be a total of 122 hours of community service. You'll also be required to attend and complete the anger management class. And you cannot have any contact with John Watts. And you will also adhere to the other standard terms and conditions of your probation. Do you understand? All right. You can just have a seat and wait for your name to be called. Let's see the next. That's Leanne Sherman.
How you doing, Your Honor?
I'm doing fine, Miss Sherman. How are you doing?
Fine.
That's good. Now, Miss Sherman, your full name is Leanne Sherman?
Yes, sir.
Miss Sherman. Get to your case. Ms. Sherman, would you please raise your right hand? Ms. Sherman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your
Ms.
Honor.
Sherman, you may put your hand down. Ms. Sherman, you're represented in your case by your attorney Benjamin Jeffries. Attorney Jeffries, do you waive a record in Ms. Sherman's case?
Yes, Your Honor.
Ms. Sherman, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Sherman, it alleged that you, Leanne Sherman, on or about February 20th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A, less than or equal to 2 ounces. Ms. Sherman, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty? Not
No
guilty?
contest.
No contest. Mr. That's a Class B. Now, Ms. Sherman, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Sherman, I also have before me a document on my tablet that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes, sir.
Now, there's one box that's checked on this document on the first page. The box that's checked states that this is a Class B misdemeanor. Range of punishment for a Class B misdemeanor is minimum 0 days to maximum 180 days in the Jefferson County Jail. A fine that does not exceed $2,000. Do you understand that range of
Yes.
punishment? Or you could be given both such fine and confinement. Now, on page 2 of the same document, there's a set of initials, LS, on the line next to a box that's check note contingent. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled discovery certification. You recognize this
Yes,
document?
sir.
And is this your signature on the line that's titled
Yes, sir.
defendant? Now, Ms. Sherman, before you signed and issued all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, he did.
And did you read and understand everything in these
Yes,
documents?
sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Sherman, are you a citizen of the United States?
Yes, sir.
State offer states 1.
No objection.
No objection. States exhibit number 1 will be admitted. And Mr. Jeffries, you advised and counseled Ms. Sherman, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Sherman, your attorney, Mr. Jeffries has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Sherman, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 20 days in the Jefferson County Jail, and the defendant is to turn herself in at or before 6 p.m. on Friday, November 1st.
Jail. To begin. You said, November 1st?
Yes, Your Honor, this Friday.
What is the court cost? No, she doesn't have any credit? She
No, Your
never been
Honor.
to jail on this case?
Not on this case, Your Honor.
I went to jail, but I was bonded out.
I know, yeah, because if she didn't go to jail, she would have a warrant out.
Yeah.
When I pulled it earlier, I did not see any credit for time served on this.
Yeah, she'll check. She might have, went in on an accusation and they let her out. Because if not, she would have a warrant, they would show a warrant out on this case. This case was filed, April 4th, April 10th, 2024. You can talk to them in the jury room. And she's out on bond, she had to go to jail.
Yeah, I went to jail, and they bonded me out, but I paid the bond when I got out.
Yeah, if she has when was the bond written? Okay, so we know she was in jail on the 21st. You got 2 days. Yes, 2 days. Okay. Yeah. Yeah, you need to put that on your plate. She's entitled to her 2 days that she served in jail.
Okay, sorry about that.
Okay, and, now, Ms. Sherman, state is offering that you serve 20 days in Jefferson County Jail, you'll be given credit for the 2 days or any time that you're entitled to get by law. The court cost in this case is $277. Are you able to pay the $277 court cost?
No, sir, not at this point.
Okay, give me her affidavit. Okay, Ms. Sherman, we'll hand this document to your attorney. He's gonna hand it to you. That document is titled Jefferson County Affidavit of Indigence. Do you recognize that document?
Yes, sir.
Now, on page 2 of that document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir, that's my signature.
Okay, now go back to that first page. Is everything on that document still true and correct today?
No, sir, I don't work here no more.
Okay, so you can strike through that, and so your income is 0,
Yeah,
okay? So Ms. Sherman, the court is gonna find that you're indigent. Based on the finding of indigency, the court cost of $277 will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Thank you. Now, Ms. Sherman, do you understand the state's offer?
yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Sherman, all follow the people are in agreement that you have entered into the state. Now, Ms. Sherman, your jail time is to begin on November 1st, 2024 at or before 6 p.m. Now, you need to bring the paperwork that they give you when you go to the jail and turn yourself in.
Yes, sir.
Okay? Just have a seat on that wall and wait for your name to be called.
Okay.
On here? Yeah. Okay, Mr. Jeffries, is this your last case?
Taft? I don't see her, she's running with a felony.
Taft? That's Mr. Gertz client on there.
About it. It will on, if you want me to, I can knock out him and one.
Okay.
Reset on him.
That's, Mr. Feldman. Okay, this is cause number 24 CCCR 2288 case of style of state of Texas versus Dylan R. Feldman. Mr. Feldman is appearing on Zoom. Mr. Feldman, please take your hat off. You're in court.
Yes, sir.
Okay, now, Mr. Feldman, your attorney is Mr. Ryan Gertz. However, Mr. Gertz is not present. His associate is present in court. Does Mr. and his associate is Mr. Benjamin Jeffries. Does Mr. Jeffries have your permission to stand in for Mr. Gertz?
Yes, sir.
Okay, and Mr. Jeffries, what is your announcement in Mr. Gertz's case? I mean, Mr. Feldman's case?
We'd ask for a reset on this, Your Honor.
Okay, give us a reset. This is, okay, this case will be reset to December 9th, 2024. Mr. Feldman, stay in contact with your attorney, your bondsman. They will be given notice of your reset. You're free to go, and you have a blessed day.
Okay, thank you, Your Honor. Appreciate it.
You're welcome. Let's see. Dante Spencer? He's here. That's another one of Mr. Gertz. He had a felony case. Mr. Spencer, please come forward. Now, Mr. Spencer, your full name is Dante Spencer? How you doing, Mr. Spencer? I'm doing fine, thanks for asking. Now, Mr. Spencer, you had a felony case set today, is that correct? And, did they give you a reset date? What date is that?
They didn't give me the paperwork.
Okay. I'm gonna have my, court coordinator to check to see if there's a reset date in the computer. If there is, we'll give you that same date. If not, then you'll be free to go. And then the court coordinator will continue to check throughout the week for a court date. And once they put a court date in, we're gonna place it on the same date with your felony. They have one? Okay. So, you'll be free to go stay in contact with your attorney and your bondsman, but your court date is gonna be on the same day of your felony. So you're gonna do the same thing you did today, come here first, check in, and then go check in, with the felony case. Once you're finished with the felony case, come back here.
Thank you.
All right, you have a blessed day. And Mr. Jeffries? Okay, you just, okay, we'll reset it this last time. The what? The court cost, you don't have to pay it.
Your Honor, on Jasmine Taft, which is Mr. Jeffrey's case on the pretrial conference docket, he said that he saw her in felony court. He's gonna go down and see if she's,
Okay, that's
there.
fine.
She never checked in with the bailiff, so
Okay.
if she's not, then we'll have to do a
Oh,
bond forfeiture.
Yeah,
Gonna go see what.
Okay.
If maybe she's still down there. I
Okay.
saw her this morning in felony court.
Okay.
She was supposed to check in here and do
yes,
this, so, but he's gonna
okay,
see if she's
Come back.
there.
okay, you're welcome. Okay,
How is that? Not here?
yeah. Okay, this is cause number 24 CCCR 1685, case of style of the state of Texas versus Jasmine Taft. We have Ms. Taft appearing via Zoom. Ms. Taft, how are you doing?
Fine, how you doing?
I'm doing fine, thanks for asking. Ms. Taft, you represented your case by your attorney Benjamin Jeffries. Mr. Jeffries, what is your announcement in Ms. Taft's case?
On this case, Your Honor, it's running with the felony out of the same transaction, I believe. So we would just ask for a reset to follow it.
Let's see.
That's correct.
Felony court date.
I felt it was that January 6th.
Okay. Ms. Taft, this misdemeanor case will be reset along with your felony case, which is set for January 6th of 2025. So on that date, January 6th, you need to appear in this court first to check in, then go to your felony case. Once you're finishing your felony case, then you'll come back here to let us know what happened in the felony. Do you understand?
Yes, sir.
All right. Ms. Taft, stay in contact with your attorney and your bondsman. They will be giving notice of your recess. You're free to go, and you have a blessed day.
You too. Thank you.
You're welcome. And,
That's it for me.
okay, you Okay. Here we go. Jefferson County Court at Law number 2 is back in session. The court is in session. With 3 dockets, announcement docket, trial docket, and the pretrial conference docket. Next case that I have is on the pretrial conference docket. And that's cause number 23 CCCR 0788. Case is styled the state of Texas versus Tyrone Hadley. Tyrone Hadley was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Tyrone Hadley at the courthouse door. Tyrone Hadley did not answer. He has not appeared in court since the court has been in session. The time now is 1:38 p.m. on today's date of October 28, 2024. Mr. Bailiff, would you please call the name of Tyrone Hadley at the courthouse door? Tyrone Hadley? Tyrone Hadley? Tyrone Hadley?
No response, Your Honor.
Tyrone Hadley's name was just called to get at the courthouse door. Tyrone Hadley did not answer. A reasonable time has passed to give Mr. Hadley an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Tyrone Hadley bond will be forfeited and a warrant shall be issued for his arrest in cause number 23 CCCR 0788. Next case is cause number 24 CCCR 2288. Case is styled the state of Texas versus Dylan. Oh, we already taken care of that one. Next case is cause number 24 CCCR 0610. Case is styled the state of Texas versus Erica Elaine Weaver. Erica Weaver was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. Erica Weaver's name was called at the courthouse door by the court's bailiff. Erica Weaver did not answer. Erica Weaver has not appeared in court since the court has been in session. The time now is 1:40 p.m. on today's date. Mr. Bailiff, would you please call the name of Erica Weaver at the courthouse door? Erica Weaver? Erica Weaver? Erica Weaver?
No response, Your Honor.
Erica Weaver's name was just called to get at the courthouse door by the court's bailiff. Erica Weaver did not answer. A reasonable time has passed to give Ms. Weaver an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Erica Weaver's bond will be forfeited and a warrant should be issued for her arrest in cause number 24 CCCR 0610. Next case is on the trial docket, cause number 23 CCCR 1618. Case is styled the state of Texas versus Caleb Blake Summerall or Caleb Summerall. Caleb Summerall was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Caleb Summerall at the courthouse door. Caleb Summerall did not answer. Caleb Summerall has not appeared in court since the court has been in session. The time now is 1:42 p.m. on today's date. Mr. Bailiff, would you please call the name of Caleb Summerall at the courthouse door?
Caleb Summerall? Caleb Summerall? Caleb Summerall? No response, Your Honor.
Caleb Summerall's name was just called to get at the courthouse door. Caleb Summerall did not answer. A reasonable time has passed to give Mr. Summerall an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Caleb Summerall's bond will be forfeited and a warrant will be issued for his arrest in cause number 23 CCCR 1618. And Mr. Bailiff, would you please make your final call for the jurors that are here for the jury trial?
Yes, Your Honor.
Now, ladies and gentlemen, what I was just doing is we have a YouTube channel and we allow the public to have access to criminal cases pursuant to Article 1.24 of the Texas Code of Criminal Procedures. All proceedings and trials should be public. And this is one of the other ways that we allow the public to have access to our trials here in County Court at Law Number 2. And some of the other courts also have YouTube channels as well. Now, as I mentioned earlier, you will be examined by the court or under its instructions for inclusion on a criminal case. So please speak up when questions are being asked, or if you have any questions that if you like to make a statement, please speak up, because our court reporter who's sitting to my left, Ms. Ada Christie, she will be taking down everything that is being said. Now, the first matter that we have is to determine whether or not you possess the qualifications to be included as a jury in this case. And then once we finish that, then we will move to exemptions or excuses. Now, also with our excuses and exemptions, some of you may wish to claim them, but you do not have to claim them if you do not want to claim the exemption. Now, when the questions are asked, we ask that you will be truthful, because if you are not truthful, and the lawyers or I discuss or discover this matter later on, this case can be retried. You could be held in contempt of court, sentenced to jail up to 180 days, and be given a fine up to $500. Now, the way I'm going to ask the first set of questions to determine whether or not you're qualified, I'm going to ask a series of questions. I do not want you to answer those questions out loud. We just want you to answer those questions to yourself. And then when I get to the last question, I then will ask you, is anyone disqualified under the law? And if you think that you may be disqualified under the law, then I'm going to ask that you will come before the bench so that we can discuss the matter more privately. And when I say more privately, what I'm talking about is we will turn off YouTube, we will turn off this mic, and we have a noise sound device that we will put on. And once we put that on, we'll be outside the hearing of everyone that's on the panel. So again, I will ask a series of questions. When I get to the last question, I will then ask if there's anyone here who feel that they're disqualified under the law. My first question: except for failure to register, are you a qualified voter in this county and state under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause before I ask the next question. And the reason why is I need you to understand that I'm asking this question because as a judge, I'm required to ask this question to see if you're qualified to serve as a juror. And then two, we're not trying to pry into your personal affairs. The question is as follows: are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was my last question. Now, is there anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel have raised their right hand, so everyone at this point is qualified. Now I will move to exemptions to determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please remain seated. Now, I will ask these questions in the same manner that I asked the previous questions to determine whether or not you were qualified. I will ask in a series, and then at the end, I would ask if there's anyone here who would like to claim any of the exemptions. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12? And jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you a person enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a pettit juror in the county during the past 3 years preceding today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from Jefferson County? Is there anyone here who would like to claim an exemption? Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. And with the excuses, I will not read you a series of questions. I will simply make 3 statements. And if you think that you would like to claim an excuse, then I'll ask if there's anyone here who would like to claim one of the excuses. Now, as a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Okay. No one on the panel is claiming an excuse, so let the record reflect that all of the members of the panel are qualified. No one is claiming an exemption, and no one on the panel is claiming an excuse. Okay. Let the record reflect that the time is 2:11 PM on today's date of October 28th of 2024. We're here in the case that is styled the state of Texas versus Hayden, well, hold on a minute. Case is styled the state of Texas versus Samuel Hayden Falk. Mr. Falk is present, and he is represented by his attorney, Attorney John Macy. The state is represented by Assistant District Attorneys, Attorney Kyle Gasper.
Good afternoon.
And Attorney Andrew Hubel. Our court reporter in this case is Miss Ada Christie. And as I mentioned earlier, Miss Christie will be taking down everything being said. So speak up when you are answering or asking questions. Our bailiff in this court is Mr. Harvey Ibarra. And I think you've already met Mr. Ibarra. The defendants stand charged in this case with driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come to the bench so that we may discuss the matter more privately. Is the state ready to proceed?
State is ready, Your Honor.
And is the defense ready to proceed?
This is ready, Your Honor.
Ms. Gasper and Mr. Macy, is 30 minutes enough? Or do you need additional time?
30 minutes is probably enough, Your Honor.
30 minutes is fine.
Okay, if you need more time, I'll give it to you. I will be taking time. Ms. Gasper, the panel is yours.
Thank you, Your Honor.
You are.
Good afternoon, ladies and gentlemen. How excited to be here today. Well, you didn't want to spend your Monday afternoon anywhere else. My name is Kyle Gasper. I represent the state of Texas and Jefferson County, and I am here with my co-counsel, Andrew Hubel. We are both assistant district attorneys at Jefferson County District Attorney's Office. Now, I'm gonna ask you some questions. I'm gonna try to make this as much as like a conversation as I can. I encourage your participation as well. It's a little bit easier on me. I don't think of this as speed dating. We're gonna go rapid fire through some questions. They might not have anything to the case, they might have some to do with the case. I'm just trying to get to know y'all a little bit better. And I ask that if you have any questions for me, if you raise your hand. If you're confused about something, raise your hand and we can clear that right up. Or if you just have any questions about what we're voting for, feel free. I want this to be as much back and forth as we can. I think it'll be most important to all. I hope you learn something. So we're here for a driving while intoxicated case. It's Texas Penal Code section 49.04. If you ever care to look that up in the Texas Penal Code later on, it's up there for you. Now we're gonna go over the elements of the crime. Can everyone see this okay? It's gonna come up in a lighter font. Let's make sure. All right. We see that okay? Anyone? All right. So a person commits the offense driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. Now, can anyone give me a definition of what they think intoxicated means? Anyone volunteer? Had a lot to drink. Had a lot to drink. It's a good one. That's a good one. I like that. Thank you. This is Dredden, juror number 9. And I'm gonna ask you all to speak up because our court reporter back here is taking everything down. So if I read your name or say your number, I'm just making sure that she has a clear statement for the record. Not trying to step over anyone's toes. So these are the elements that I have to prove as the state. We have the burden of proof. And a person commits the offense if all three of these elements are met. You said intoxicated means having too much to drink. Also, a bit of a misconception in that is that being intoxicated is not the same thing as being drunk, legally speaking. The defendant does not have to be drunk to get charged and convicted of a DWI. The defendant has to be intoxicated. Now, we have 3 definitions of what it means to be intoxicated. Did you have a question? You want to make sure. Intoxicated means not having the normal use of his or her mental or physical faculties by introduction of alcohol and or drugs or a BAC of 0.08 or higher. Now that's a lot. I'm going to break it down a little bit more. That's 3 different ways that a person can be legally intoxicated. So intoxicated in Texas. We have the first one. You have not having the normal use of mental faculties. Can someone give me a definition of what a mental faculty might be? How about you, juror number 1, Mr. Oxford?
Paying attention to the road, knowing what's going on around you, that type of thing.
Yes, thank you. That's a good one. So mental, you can't fully function in your mind, lose your mental faculties. Now the next way you can be intoxicated, if you don't have normal use of physical faculties by reason of introduction of the alcohol and or drugs into the body. Anyone have a definition or an example of what a physical faculty might look like? Ms. Strotter, juror number 3.
So uncoordinated, can't control your emotions and actions.
Perfect.
Yeah.
Yes, that's perfect. Physical faculties or anything physically that you cannot control. You said coordination, things like that. That was perfect. Thank you. And finally, intoxicated in Texas can also mean having a BAC or blood alcohol content of 0.08 or higher. Now, the state of Texas has to prove that the defendant is intoxicated, but we do not have to prove all 3 of these. Our burden to show that the intoxication element was met to prove one of the 3. Now, you might see more than one, but our burden of the state is to prove one of the 3. Does anyone have any issues with that? Do you feel like we have to prove all of the above or more than just one of the 3 to hit what it means to be intoxicated? Does anyone have any questions, comments, concerns about that? Any all 3 without those? Any issues with that? All right. So why do we have 3 definitions for intoxicated? Like I just said, it's because our burden is to prove intoxication. And there are 3 avenues that we can prove that by. And we can have mental faculties, the physical faculties, or a BAC of 0.08 or higher. All of those satisfy what it needs to be. Now, okay. I'm gonna go back to the elements. I'm just keeping in mind one for the rest of the presentation. Why do you think these types of laws exist? Why do you think the lawmakers in Austin created a driving while intoxicated law? Anyone? Yes, Mr. Stewart, juror number 13.
Yeah, prevent crashing.
Prevent crashing, yes. Prevent people from getting into unsafe conditions, crashing, things like that. I agree with that. Thank you. Someone else had their hand raised. I was gonna say, if you can say, yes, safety. We're concerned with safety. We want to make sure that the roads are a safe place for people to drive. One of the reasons why we have these types of laws. We have lots of laws. We want to keep people safe. Do you think that the state should be prosecuting these types of crimes? Look like I was gonna say absolutely. Yes, thank you. Once again, we come back to safety. We're circling around the safety. We want to keep people safe. And to do that, we have to enforce the rules, we have to enforce the laws. And that's why we're here, is to meet that burden and enforce the laws in the way that they are written. Now, just Gonna go off softball questions here. Does anyone know what the presumption of innocence is? Any idea what the presumption? Anyone want to take a shot at it? Thank you. Juror number 6, Mr. Nguyen. Thank you. Now you said innocent until proven guilty. You're almost there, but it's gonna be innocent unless proven guilty. There you go. So the defendant in this case and any criminal case is innocent unless proven guilty. And that means that the defendant and the defense, they don't have to do anything in this case to prove that the defendant is innocent. They can sit here, they don't have to call any witnesses, they don't have to do anything because the presumption of innocence exists. And going off of that presumption, we were right on track with that. Thank you, juror number 6. We have the burden of proof. And our burden of proof is beyond a reasonable doubt. And we, as the prosecutors, have to prove beyond a reasonable doubt that all 3 of these elements are met in this case. That the person was intoxicated while operating a motor vehicle in a public place. Now, we have the burden of proof, and if you are picked for this jury, you're going to get to hear the facts, and you're going to get to hear the evidence, and you're going to get to, at the end of the day, whenever we are finished with testimony, determine whether or not the state has met their burden of proof. Now, another thing I want to touch on in the area of presumption of innocence and burden of proof. I know there's a lot of big words being thrown around, but they really do have simple meanings. Does anyone know what the privilege against self-incrimination is? Or have any idea what the privilege against self-incrimination is given the name?
You don't have to say anything about what you did or what you were accused of.
Yes, jury number 3, Ms. Strotter, that was perfect. You have the right to remain silent. You do not have to talk. You do not have to testify. The defendant does not have to take the stand and tell you his ideas of what happened. He has the privilege against self-incrimination, and you, if we pick this jury, cannot hold that against him. That doesn't mean that you can use that as evidence in the case. Is everyone okay? Understand what that privilege means and means that they do not have to testify in this case. Anyone have any issue with that? Seeing a lot of head nods. You good? All right. Now, in a driving while intoxicated case, what type of evidence would you want to see to be able to find that the prosecution met their burden of proof and convict someone for a DWI? What type of evidence would you want to see? Yes, juror number 13, Mr. Stewart?
I would like to see some video evidence,
Video evidence, like body cam footage, for example?
or like traffic cam or any kind of camera.
Okay, yeah, video evidence, that's a good one. Anyone else want to see some sort of video evidence, kind of see what happened? All right, any other types of evidence you might want to see? Yes, juror number 4?
I'm gonna say email.
Any damage? Yes.
Like, it is, bringing towards.
Yes, damage, I like that. It's a good thing to be able to see. Does anyone like to see some damage in this type of case? Thank you for that answer, juror number 4. Anybody else, any other types of evidence we might want to see?
Blood alcohol.
Blood alcohol. Yes, juror number 3, thank you. That's an important one. It's a good piece of evidence to see in a case like this. Now, following up with that, what type of witnesses might you want to hear from in this type of case? So you've seen that you want to hear, you want to see some video, you want to see maybe the blood alcohol or damage, if there is potential damage. What type of witnesses would you want to hear take the stand in this type of case? Yes.
The church or police officer that conducted the stop or whatever.
Police officer, yes, good one. Anybody else, any other types of witnesses? Bystanders, someone who observed the incident take place, anybody else?
I would say the actual person, if it was involved with another person or.
So if there's another person involved, you'd want to hear from them? Absolutely, those are all great answers. Good things to help you all build your case and figure out what's going on, understand the facts and apply the facts to the law. Now, how should witnesses be treated? We've talked about a few types of different people. We have police officers, we have bystanders. Do you think that these witnesses should be treated the same when they take the stand? The same or different? Mr. Otter, you said the same? That's a perfect answer. That's what I was going through. I didn't word it very well, and I apologize for that. Yeah, I started running with it and I didn't go exactly where I wanted it to, so I apologize. But yes, we want every witness that takes that stand, when they're on the stand at the beginning, they're given the same level of credibility. That means if you hear from a police officer, if you hear from just a bystander who happened to be there, they are all given the same level of credibility when they take that stand. Can everyone agree to hold everyone to the same level of credibility when they take the stand? You don't have a problem with that? All right, now, I want to talk a little bit about your duty as a juror. Now, you're here for jury duty, and y'all do have a duty, and your duty is the most important in this case. We would not be able to be here without you. We cannot do our job and prosecute these cases without you. Now, your duty comes down to 3 steps. You decide the facts, and you'll do that if you're picked in this case by listening to the evidence, and you'll apply the facts to the law. This is the law, and you'll get it again tomorrow. You'll get it when you're going into deliberation. You will get a copy of it, and then you have to follow the law. Can everyone agree to follow the law and keep personal opinions and things like that out of your decision? You have to follow the law in front of you. Can everyone do that? All right, that brings me to my next point, and I am sorry, this might be a little bit hard hitting, like Judge said earlier. If there's something that you want to discuss with us outside the presence of the rest of the jury, please just let us know. We can take time after we're both done with our questioning to speak to you individually if you want to tell us a little bit more. Now, does anyone know someone who has been charged with the DWI? Show of hands is fine. Yes. All right. Quite a few. All right, I'm gonna go down the list and get a little bit deeper into these. Mr. Perez, did you raise your hand? You said you
Yes,
knew
ma'am.
someone? Now, would your relationship with that person affect your ability to be fair and impartial in this case?
I don't know, it's me.
Okay. Thank you for being honest about that. I appreciate that.
It was so long ago, it was over 30 years ago. so.
Okay. Knowing what I've told you right now at this stage in the process, do you think that that would affect your ability to be fair and impartial in the DWI case?
It wouldn't affect
It wouldn't affect it. So you'd be able to be fair and impartial. All right, thank you for sharing. I really appreciate that. Miss Dreden? Dredden? Apologies. You raise your hand as well? I know people. You know people? Would those relationships affect your ability to be fair and impartial? All right, thank you. Anyone else on this front row know someone with DWI? All right. Ms. Wolf? Would that relationship affect your ability to be fair and impartial? Thank you. Mr. Harris?
Yeah.
Would that relationship you have affect your ability to be fair and impartial? Thank you. Mr. Stewart, did you raise your hand as well? No. Sorry, a bunch of people, I'm just trying to make sure I get everyone. My co-counsel just informed me that you raised your hand too. I'm sorry, I missed you, Mr. Oxford. Would your relationship with those people affect your ability to be fair and impartial? Now, I know I saw some on the back row. All right, we're gonna go backwards. So we start with Mr. Stewart. You said you knew someone that's been charged with the DWI?
Yes, I think knowing, the defendant would impact my ability to have impartial, view on it.
So it would prevent you from being fair and impartial in this type of case? All right, thank you for sharing that, Mr. Steele. We might call you in for further questions later on. Mr. Brownsberger, you say you know someone?
Yeah.
Have no problem being fair and impartial?
No.
Thank you. Anyone else? Yes, Miss Worthington? Will that relationship with those people prevent you from being fair and impartial? Thank you. And Connor, did you raise your hand? I did. Ms. Smith, did you raise your hand? Okay, I got everyone. Now the next one, and this one is a little bit harder of a question. Like I said earlier, we need to talk to him outside the presence of the other jurors we can. Does anyone know someone who's been a victim of the DWI? Any hands on that? Victim? Been injured, anything like that? Nothing? Okay. That's okay. Thank you for,
I've had some clients who are victims of violence, so.
okay.
in my practice.
And I knew on your, you indicated that you are a lawyer. Would that relationship with those clients affect your ability to be fair and impartial?
No.
Okay, thank you. Now. I'm just trying to make sure I cover everything before I sit down. Y'all are being very helpful. You're helping me get through all my questions very quickly. Now, before I pass the baton to the defense, does anyone have a problem sitting in judgment of another human being? Yes, Ms. Hayes? Do you have an issue with sitting in judgment of another? Is that something that would prevent you from being fair and impartial if you were picked from this jury? No, it would not. If I do ask you a question, I'm gonna ask you to please say yes or no so that the court reporter can do it, because she can't record body language, so thank you. So it would not keep you from being fair and impartial in this type of case. All right, thank you. I hope that you've all learned a little bit something from me. I hope that you all had a good discussion, and I leave you with this. Thank you for being here. We really appreciate it. We could not do our job without you. I'm running in the defense counsel. Thank you.
Mr. Macy, the panel is yours.
Thank you, Jen. Good afternoon. My name is John Macy. I represent Samuel Falk. He's the defendant in this case. And hopefully it won't take too terribly long. I tend to ramble sometimes. So what do you believe a juror's job is? Ms. Straught, is it Straughter? Straughter. What do you believe the juror's job is?
Determine guilt or innocence. Listen to the evidence and make a decision from that.
Okay. Did any of y'all hear what she said? It's very difficult when y'all are sitting facing me to hear some people that talk toward me and not toward y'all. And so, yeah, apologize. I'm gonna try to say what you said. I believe you said to determine whether they were guilty or not guilty.
Guilt or innocence after listening to the evidence presented.
After listening to the evidence. How easy is that to do? Y'all, have an opinion on that? Ms. Johnson,
I
you
don't
think
believe,
that's easy or hard?
I don't believe it's easy.
I'm sorry, what?
I don't believe it's easy. It's not easy.
Not either. If you had to say, is Mr. Now, when you walked in and you were sat down by the bailiff, there was a screen up there, right? Did y'all see that? And it said, driving while intoxicated, right? Did anybody not see that? So before anybody said anything, y'all knew what the case was about, didn't you? Okay. Is there anybody who didn't know what the case was? Can I see a show of hands? I don't see any hands, so I take it that everybody knew it was a DWI case. Just because you sat down. Okay, so now that you knew it was a DWI case, if you had to say, now you didn't know Samuel's name, I take it. Does anybody know Samuel? I don't see anybody, raise your hand if you know Samuel.
I may know Samuel.
You may know Samuel, okay. That's Mr. Steele. Where would you think you might know him from?
Just around the community.
Okay. If you had this, if I asked you right now, because you saw that, if you had to vote right now, is Samuel guilty? Raise your hand if you think he's guilty. Nobody's raising their hand. Okay, so is Samuel not guilty? Raise your hand. Mr. Oxford raised his hand. Nobody else did.
If you're presuming he's innocent until proven
Thank
guilty,
you.
then
That's Ms. Wolf.
yes.
Everybody should have raised their hand. You've heard no evidence in this case yet. So Mr. Paul is presumed innocent. And he is innocent unless the state proves beyond a reasonable doubt that he's guilty. Okay, now we know, I presume we know that he's been charged with driving while intoxicated, is that right? Oh, because he's sitting here. And that's why I asked you, Ms. Johnson. Whether, how easy it was, because it's kind of confusing, isn't it? I've had jurors, the dire people, that's what y'all are right now, you're on the board dire panel. You're not a juror. The juror sits over there. But right now, you're a prospective juror. And I've asked that question. Actually, in a lot, it's a felony case, but anyway, somebody in the back said, well, they're guilty. And I asked them, I said, well, why do you think that? And they said, they wouldn't have been charged if they weren't guilty. Does anybody believe that? Won't see anybody's hands. So I take it that you don't believe that, although that juror, that Benire person, absolutely believed that. There was no, I tried to, explain to her that, there's a presumption of innocence and all of that. It didn't matter to her. The person was guilty. She was sweating. And so does she have the right to believe that? Does anybody believe she doesn't have the right to believe that? Because she absolutely has the right to believe that. You have the right to believe anything you want. Does that mean that she should have been on our jury? And everybody's just kind of looking at me. So I'm gonna pick on somebody, Mr. Perez. Does she have a right to be on our jury?
I wouldn't think so.
If she is predisposed, already thinks somebody's guilty before she's even heard any evidence, she's not an appropriate person for that jury. I would submit to you. Okay. And the reason that I was kind of harping on asking that question about whether being a juror is easy or not is because people, and this is my opinion, okay? I tend to look at things, I'm sure, way differently than the state's attorneys do. But my opinion is that, well, everybody has preconceived notions, right? you grow up, everybody has different attitudes, you have different experiences, right? So those experiences, I believe, will affect the way you perceive things. It's natural, and that's perfectly fine. What we want, I believe the state wants the same thing I want. We want a juror that's fair, who's not already decided that Mr. Falk is guilty. We want somebody who will listen to the evidence and decide whether they proved their case. So I'm gonna ask, I know Mr. Perez was gracious enough to tell us that he got charged a long time ago with the DWI. Does anybody else, is there anybody in here that's been accused of a crime? Let me raise your hand.
Accused of crime.
Okay, I'm sorry, what did you say, Mr.
Accused, yeah.
What?
I have been accused of a crime.
Okay, I'm not gonna ask you what it is, but so everybody, Mr. Oxford raised his hand and Mr. Steele raised his hand. Everybody else did. So nobody here's got a traffic ticket. Right? Or have you got? Y'all know that a ticket, being accused of getting a ticket's a crime. It's not a very serious, but it's a crime. And I bring that to you to say that I don't know whether you committed the offense of whatever that ticket was for or not. But you're presumed to be innocent of it. And people tend to characterize crimes in certain ways. And so I just want to point that out. There's different crimes. So what are we looking for, do you think, Mr. Wynn? What are we looking for in a juror?
Fair and impartial.
Fair and impartial. What does that mean?
You're not biased towards what you're saying for, if the defendant is guilty before any evidence is produced.
Did y'all hear him? He basically said, you're not biased and you don't decide what the evidence is until you hear it, I think is what he said, something like that. I tend to be a little more, because of, I did what I did, okay? I look at things a little differently. I look at things more broadly because I understand the process, how this is working. And I know a few of y'all I saw in your jury cards have been on criminal juries before. And a few of them. But basically what happens from my perspective is we're going through this right now. The state asks y'all some questions and then I'm asking y'all some questions. And ultimately, 6 people are gonna get picked on it, or you're gonna end up on it. You're not picked, you're left over, so to speak. And the 6 that end up on the jury are gonna get seated, they're gonna get sworn in, and they're gonna listen to the testimony, they're gonna listen to the evidence. Or they're gonna hear the evidence, or however you wanna say that. Ms. Hayes. What types, and you were, I think you asked already what types of evidence you think you would hear, right? But do you have any idea
Evidence that we would hear.
what type of evidence is presented in a criminal case? You know,
The evidence found against the defendant usually.
I'm sorry, what?
Evidence found against the defendant.
Against.
Or
Yeah, well, yeah, I mean, in a way, you're right. They have the burden of proving that Samuel was driving while intoxicated, so they're gonna be presenting evidence that they think proves that, right? But basically, there's testimonial evidence, right? Testimonial evidence is evidence that a witness is gonna tell you from the stand, okay? And they're gonna say whatever they have to say about something. And then y'all, the jurors, have to listen to that. And you have to decide whether you believe everything that they're saying, some of what they're saying, or none of what they're saying. That's what y'all do. Y'all decide as the judges of the facts, what you believe and what you don't believe testimonial wise. Now, there's also physical evidence, okay, which would be if it was admitted in evidence by the judge, a phone, if it was important. If it was very important, if it was something that was required, and they forgot to have it admitted, what happens then? You find the person guilty or not? It may be that you have to find the person guilty. I mean, not guilty, I'm sorry. Misspoke. If the phone was so important that was a crucial piece of evidence that they forgot or it was kept out and they needed that, then what would your verdict have to be? If it wasn't part of the evidence, I would submit to you, it would have to be not guilty. It's very difficult from my perspective to even get a juror to say those words. So I want you to say important ones. Say not guilty. Did that leave a funny taste in your mouth? I'm just curious. And then the last type of evidence is what they call, well, I think it's the last type, is what they call demonstrative evidence, which is like, or circumstantial evidence or something, and is evidence that is derived from something else. But anyway, so now I asked y'all about me, or actually I asked you about Mr. Falk, but nobody here knows me, do you? Is there anybody here who knows either one of the prosecutors? Joanne, no? Is there anyone here who's ever worked for the district attorney's office? Is there anybody who knows somebody that works for the district attorney's office? Mr. Steele, you know somebody from the district attorney's office. I presume Mr. Oxford knows somebody from the district attorney's office. Does the fact that you know somebody in the district attorney's office is going to affect your ability to be fair and impartial in this case? If it is, please raise your hand. And I don't see any hands raised. And this, does anybody here work in law enforcement? You're, Mr. Cox Todd? Yes. You work for BOP, Bureau of Prisons. And I don't know, that might count, but it doesn't matter. I know that you happen to work for BOP because you wrote it down, but some people don't. And that's why. Now I do know that Ms. Redden?
Yes, sir.
Your husband works for DPS. In fact, he's a Texas Ranger, is that right?
Yes, sir.
So he is the very definition of law enforcement,
Yes, sir.
correct?
Yes.
The Texas Rangers investigate potential wrongdoing by other police officers, right?
Yes,
And which is great. Because sometimes police officers do things that are wrong. And they should be investigated. Sometimes. Is anybody here a member of Mothers Against Drunk Driver? It's okay if you are, I mean, I just was curious, is that I don't see anybody's hand, and so I take it that you're not a member. Or what about a spouse? Anybody's spouse a member of MAD?
I got I was gonna make a statement. I have a brother's, that's a police officer in Houston.
HPD?
HPD, yes, sir.
Yeah, I have that written down somewhere, I think. Your brother and you're the one that you retired from AT&T.
Yes.
And I did see that your brother worked for APD. And the fact that is he a patrol officer?
He's been on the force for 27 years, but he's actually, training a lot of recruits that come out of the academy.
I see.
But he was worked strictly graveyards.
Yeah.
That's all he worked was strictly graveyards.
Okay. And the fact that he does that, that wouldn't affect your, ability to be fair in this case, right? You talk to him much, Stephen?
We talk, every day. Yeah.
Good. I'm glad that you have
You got a relationship.
I regretted asking you that question the moment I said it.
Right.
They talk about, they have to prove these elements, okay? But it's not just that they have to present evidence. They have to prove the evidence beyond a reasonable doubt. Has anybody ever heard that term? Mr. Oxford, what do you think beyond reasonable doubt means?
Well, it's very difficult to define. It's not an absolute. You can have some doubt, still have, not reasonable doubt, but you gotta be pretty dang sure.
Gotta be pretty dang sure. The reason I picked on Mr. Oxford is because he's a lawyer. And I know that he knows some of that. It's a very abstract notion beyond a reasonable doubt. Used to be that there was a definition for it that we would give jurors in the charge. And the legislature or the I guess the Court of Appeals or the Court of Criminal Appeals, whoever it was, decided that, oh, no, we're not gonna give that definition to the jurors anymore. Don't know why they did that. I don't know if they had an agenda or what, but we no longer tell you what that is in state. If we were in federal court down the street, that definition would be given to the juror. And it's the exact same definition we used to give in state court. That they still give over there. But in their infinite wisdom, they decided that the juries don't need to be told what that is anymore. That they say, oh, you'll know it when you see it. And I don't know if that's right. I like Mr. Oxford's definition far better than the definition that, oh, you know it when you see it, because I'm not sure that the average person does know that. It's a very high standard. And so if you have a reasonable doubt about one of the elements, what's your verdict supposed to be, Ms. Bob? Is it? That clear, Bob?
Mr. Mason, you have 5 more minutes.
Thank you.
Could you repeat the question?
I'll try.
I'm sorry, I have to.
If you have a reasonable doubt, what's your verdict? Not guilty. Right. They have to prove beyond a reasonable doubt that, whatever the elements of DWI. But I'm gonna get back to what I was talking about before. So you're on the jury and you're listening to the evidence, and they're gonna have a certain opinion about what it is. And I'm gonna have maybe a different opinion. But what their opinion is and what my opinion is doesn't matter. Because they're our opinion. Y'all decide what they prove beyond a reasonable doubt to you. Each and every one of you. And so when I asked Ms. Johnson about how hard is it to be a juror and just do what you're supposed to do, and she said it's hard, and I agree with that. But the reason I agree with that is because you know what the prosecutor told you was the law. But you don't really know what the law is until the judge gives it to you. Okay? So how this works is you're going to listen to the evidence. And then once you hear all the evidence and they rest, then I may or may not do anything. Because I don't have to prove that Samuel's not guilty. They have to prove that he is. But I may do something, I don't know. But eventually when I rest, then the judge is going to read the charge. And so why I was saying it's so difficult, in my opinion, is because what we're looking for in the jury is someone who can listen to all the evidence, but not decide until they know what it is that they're supposed to prove. And so you won't know that for sure until the judge gives you the jury charge. And when the judge gives you the jury charge, then you're gonna go back into the jury room and pick a foreman, and then you're gonna start to deliberate and try to decide, did they prove beyond a reasonable doubt everything they were required to prove that the card says. And then you make your decision. And what I'm trying to get y'all to do, what I've hoped y'all do, is not decide whether Samuel's guilty or not until you've heard everything. And until you go back there and read the charge and know what it is they're supposed to prove. And then you can decide, did they prove it or not? And that's what I'm looking for. So anyway, I'm basically out of time, but I'm more or less said, I think, what I wanted to say. Does anybody here have any questions? Because this is the only time we get the opportunity to actually talk about it. After this, if we see you in the hall or something, I might smile, but I won't talk to you. I can't, and they can't either, because it can't have an appearance even of an impropriety. And so this is your chance. Miss, yes, sir. How long is the trial? I'm sorry, what? How long is the trial? How long is the trial? Yes. It's as long as it takes. I don't know. I don't know. But hopefully it won't be too terribly long. I anticipate it being over this week. Might be over tomorrow. I don't know. I have no idea. Real fast. See, there was something came out. Mr. Stewart, your cousin is a detective. You're kind of detective. A law enforcement, like a detective.
Yeah, he's
I'm sorry, what?
yeah, he's law enforcement.
Law enforcement, where at?
No, he works around you.
I'm sorry, what?
I think I know he works around Meterman.
Meterman?
I know he goes to Social Practice.
Okay. Is the fact that he's on a detective that would have any effect on you in this case? Ms. Wolf,
Yes, sir.
your teacher,
Yes,
and who's the captain of the Port Arthur Fire Department?
that's my youngest son,
I'm sorry, what?
my youngest son.
Your youngest son.
The chief, just the captain on one of the ships.
Does he, I'm sorry, what?
He's just the captain on one of the ships, like he's not in charge or anything.
On one of the ships?
Shifts,
I'm
yes.
sorry, I wear hearing aids.
Okay.
I thought it said ship.
Okay.
And, so is he on a truck or is he in like I don't know how they
He
do that.
drives on a truck.
Okay. Miss Hefner Bob, you're used to be a federal librarian?
No, I was a government documents librarian. So universities frequently have a depository library where you get government materials.
And so you were responsible for ordering those and
Yeah.
collecting those and that kind of
Yeah.
thing. Okay. Worthington. Your sister is in law enforcement.
I don't know what exactly she does, but.
Where?
Your corpus.
Near Corpus, okay. I appreciate y'all coming. And I hope you, or I look forward to present my case, possibly, to some of y'all. Thank you.
Okay, ladies and gentlemen, we're gonna ask that you go into the hallway. You can go out either one of the doors. And we may call some of you back in for some follow-up questions. Okay, everyone, please stand as the panel exits the courtroom.